The agency has tried to calm fears by making clear that we will be reasonable in our enforcement policy, but we cannot waive the law. Only Congress can change it. The second problem that I see is with the scope of the law. And by this I mean, does a product manufacturer have to test and certify to the lead and phthalates requirements of the law, even if its product does not contain lead or phthalates? Let's take lead as an example here. We're trying to answer that question rationally by pointing out that there are certain kinds of materials, like fabrics, untreated wood, ordinary books, minerals, certain kinds of metals, that we all agree just consistently fall below the lead limits of the new law. And therefore, those sellers do not have to test. And we do not plan to spend our enforcement resources looking at that category of products. In addition, certain electronics found in children's toys are exempted from the requirements. However, there are other products that contain lead above the prescribed limits, but at the same time do not present any known health risk to children. With respect to those products, we have proposed an exclusion process. But Congress has really cabined in our ability to grant exclusions, even in those situations where we don't think that there is a health risk. So this is an example of that lack of flexibility in the law that I was talking about. So unless Congress changes this provision, and I see very little indication that they are going to be doing that, industry should not count on exclusions as a practical way to avoid re-engineering their products. Well, I realize that you are being asked to spend resources at a very difficult time to address a problem that doesn't really seem to have much to do with safety. You must understand that the Commission's hands are tied on this one. Defining the scope of the law has also been a problem with respect to the new phthalates requirements. The agency believed initially that the new law applied only prospectively with respect to its ban on phthalates, and so did not apply to inventory. But as you know, we were overruled in that interpretation by a federal district court judge up here in New York. And so consequently, with little or no warning, inventory has suddenly been pulled into the phthalates provision. For a variety of technical legal reasons, the agency is not appealing this decision. But I note, however, that no one from the toy and the child care industry intervened in this case. Had you done so, you all could have appealed this decision. But be that as it may, the Commission has now developed a method to test for the presence of phthalates, which was published last week on our website. We have also just published a request for comments on a guidance document which tries to give some clarity and define what kind of product is within and outside the ban on phthalates. And I would ask that you all take a look at those two documents. We would like to have input from industry on whether we are headed in the right direction there. Although the agency's latitude and flexibility is more limited than I would like, we've tried to also address other key issues that I think are especially important to your industry. For example, we recently stayed enforcement of certain testing and certification requirements for at least 1 year. This has given industry, both large and small, some relief. We adopted this stay of enforcement on the testing and certification provisions because we felt that more time was needed to get in place some underlying regulations that I think were foundational to make sure that the testing and the certification requirements really worked. And so let me call out for you 2 of the underlying regulations that we are now working on during this hiatus period, because I think you all will have some insights that the agency can use as we go through this regulatory development process. The first deals with composite and component testing. There's been a lot of talk about these 2 issues, and the question really revolves around, first, whether or not component testing is allowed as a substitute for testing the final product, and secondly, under what circumstances, if any, is composite testing acceptable. The law is somewhat ambiguous with respect to both issues, but we are working now on a rule to address these issues during this hiatus period. The second regulation that we're developing that I want to call to your attention deals with tracking labels. I think that the tracking and the labeling rules that we are working on are really fundamental to making our whole regulatory system work. Ideally, Congress would have sequenced the law a little bit differently, and it would have made these regulations the first order of business, but they didn't. So what we are trying to do is work on getting some tracking and labeling rules in place before the testing and certification requirements kick in. I think that it is very important in our rulemaking process that the agency pay attention here to similar issues, activities, and regulatory responses in Europe and in other countries. Harmonized regulations are really important here. This is a very complex issue, and I really would like to see you work with us as we try to craft our rules here. When the legislation outlining the CPSIA was first proposed, it was my hope that we would soon see a law that would increase the resources and tools of the Commission and thereby protect American families. What we have is a well-intended law, which experience has shown was not as carefully crafted as it could have been, and which is now having a very regrettable impact on jobs and on small businesses. But it is the law of the land, and it is the Commission's and my job to implement it in as realistic and as practical a manner as possible. So if that's our role, what is the role of industry going forward? Well, your first obligation, of course, is to know the requirements of the law and to comply with it. As I've said a couple of times this morning, the Commission really does want to work with you. We really don't have any interest in putting out of businesses companies that are honestly trying to comply with the law. But make no mistake, while we will be reasonable in our efforts to enforce the law, we will enforce it.